The hearing opens with one fact already carrying more weight than every accusation that follows. There is a standing court order, and one parent claims it was ignored without explanation. That immediately shifts the discussion away from emotions and into enforceability.
Number FM 22-000172, Brown versus Jordan. This case is set for an hour, so Miss Fatima will put an hour on 30 minutes on the clock for each side. I understand that the controversy here is about Mr. Brown getting access to the two children. I also note that I've reviewed the order establishing the parent-child relationship that was filed in Travis County here on April 19th of 2022. Did you start a new file? No. All right. So, and I've noticed that Mr. Brown has filed a petition for writ of habeas corpus to return the children to him. And in a declaration, he explains that he has come to Texas at the end of this past school year. He let her know in advance he was coming. The only answer he got was no, and no explanation. And he says that's Miss Jordan, expressed countless times that she did not care about court orders and she'll do what she feels. Obviously, that is not acceptable behavior. The law in Texas assumes that it's in children's best interest for them to have time with both parents. There's an order in place that provides how and when that time should be provided. So let me hear from you first, Ms. Jordan. Well, let me go ahead and swear you both in. Both of you raise your right hand and be sworn. Do each of you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
I swear.
Swear.
All right. So I've heard from the pleadings what Mr. Brown's side of the controversy is. Ms. Jordan, will you let me know what, if anything, is incorrect about what he said?
Yes. So as far as the children not being able to see him, I have stated several times, even in the exhibits, I do not mind him coming to visit the children or taking them back to California. The issue that we keep coming towards is it is his responsibility to get them to California. I've told him countless of times he is able to see the children. He does come and see the children. When he does see them, there's no hotel fees. There's no anything he has to spend out of pocket. It's just a travel fee, and I provide the place for him to stay. So I never stop him from talking to them, seeing them, or them visiting them. That's never a thing for us. So I completely disagree with his argument.
All right. Well, is it true that he came to your house on May 23rd of this year at, well, no, it said he gave you notice that day. What was the date that you got there, Mr. Brown?
I arrived at her place May 12th. So she allowed me to stay there from May 12th to May 23rd. May 23rd was the day that I gave her the paper basically stating that when, they're out of school on June 15th, I'll be there to pick them up and basically take them for the summer. and I gave her the visitation enforcement paper. I do have a video of me doing so. I just been kind of having problems sending it into the box, and I think it's due to me being on the Zoom. But I may have sent it, I may not, but I have both recordings of me speaking with her and letting her know I'll be back on the 15th, and me as well arriving to her establishment on the 15th. So
Um, so yes, Judge, am I still going? Sorry.
Yes, go ahead.
Yes, so he did arrive in May. There was 3 failed attempts, as you can also see in the exhibits, 3 failed attempts for him to come. So when he actually decided to come, I allowed him to stay at my apartment for, I think, I don't know if it was 2 weeks or one, but he stayed for quite a bit of time. He had that time with the kids by himself. Prior to him coming, I did explain to him, June, they have something that they were wanting to do. He has not followed the court order. He has never picked the children up. So they had something to do. It's my responsibility as the mom who works and have to make sure the kids are occupied while I'm doing so, to make sure they're good to go. So I did explain to him in June. They do have a program, a summer program that they will be attending. So June is not up for grabs. He agreed. That's why in the exhibit, you'll also be able to see when he said, when are you guys leaving for June? Or when are you leaving for June? Something like that. That was what that message is from. We did talk about that. So when he did come to the apartment and stay with the kids, the very last day of him staying, that's when he presented the paper and he was like, I'm taking my kids for the summer. I should be able to have them for June and July. When we agreed, July will be the month that he gets them. And we actually discussed, my birthday is July 17th. I said, you can have them July 17th and you keep them from there. He was like, that's not enough time. I said, okay, well, you can get them July 1st and keep them till then. It doesn't matter. The month of July is yours. June, they are occupied and I already paid for a program. He said he understood that, and that's what it was. And then it all changed after his visit. So that's what happened there. And this is how we got to the whole court situation. So.
All right,
may I reply to that statement?
you may.
I spoke with her. I mean, excuse me, that is not. I spoke with Miss Smart, the mother of my child, January 15th, to ask about schedules of the children's time that they're getting out of school via spring and summer. I was forced to do the looking for myself because she did not provide it for me. So when I found out it was June 15th that they were initially getting out of school, I asked her,
This section exposes the difference between cooperation and legal compliance. The judge carefully separates what parents prefer from what the order actually requires, refusing to let either side redefine the rules through personal convenience.
When are you guys supposed to basically leaving and coming back? I do have the messages. I sent it in because prior to that, we did have a conversation and she tried to explain to me that the children were going to be gone all of June. And I expressed to her that I don't approve of that. And it's been since I've never got to give my children due to a lot of actions that I from her side as well as mine, because at times I didn't have the funds, and due to the fact that she would not allow me just to fly my children out with an attendee. She was trying to make me fly out there, then pick them up and fly back, and then fly out there, drop them off and fly back. I told her I'm not financially, I don't have enough finances for that type of trip. So I've offered her, because I just got a car last year, I've offered to drive out there and pick up my children and drive back. And I've also offered to fly my children out here. And if she wasn't comfortable with me flying just them, I offered to fly her as well so they can all come and visit me. And she denied that. So yes, even when she did try to mention she had something to do for June, I wasn't in agreement with it. I just, when she told me that, that's when I did my homework to really check to make sure, like, okay, when are my daughters getting out of school legitimately? Because I don't know. So when I
Where
found
did
out the
they go to
question,
school?
they go to Camacho Elementary, if I'm not mistaken. Tomorrow I'd be better off telling you that.
Is that in Pflugerville ISD?
It is Leander ISD.
And again, so like I was expressing to her multiple times, like I'm in a position where I can at least pick them up now, so where I don't have to spend all this extra cash that you want me to spend to fly them out. I can just pick them up. So with doing so, that's how my visits started to happen within the last year. I started just driving to see my daughters. And yeah, this last time I told her I'm going to make the commitment to drive out there to pick them up again and drive back. And she told me that, well, she basically denied me for one. And yeah, so, and I told her, like, yo, we have a court order. This time around, I'm actually going to go forth with, these proceedings because prior times it was just a back and forth thing. Sometimes she, you know what I mean, I'll get blocked for a couple months or we wouldn't speak, and then that'd be times of my visitation I was supposed to. So it's a lot, but just here in this position situation alone in general, I notified her. I had the funds. I came on the time that was allotted when I'm supposed to get them. I was denied, and I told her if I'm denied, I will have to do this. So this is what I'm doing, and yeah.
So let me just say this. In the order establishing the parent-child relationship, it's a 25-page order that was signed by Judge Mary Morton on April 19th of 2022. And each of you also signed it, along with a lawyer from the Attorney General's office. And it provides for parents who live over 100 miles apart, which y'all are. On page 9, it says that Mr. Brown gets possession of the children every year, beginning at 6 on the day the child is dismissed from school for spring break, and ending at 6 the day before school resumes after that. And for summer vacation, if he gives written notice by April 1st of each year specifying when he wants the children, then he shall have possession of the children for 42 days, beginning not earlier than the day the child's school is dismissed for summer vacation and ending not later than 7 days before school resumes at the end of summer vacation, to be exercised in not more than 2 separate periods of at least 7 consecutive days each, with each period of possession beginning and ending at 6 p.m. on each applicable day. If he doesn't give the written notice by April 1st, then he gets them automatically for 42 days beginning on June 15th at 6 p.m. and ending on July 27th at 6 p.m. Those are the requirements. You can also give notice, Ms. Jordan, for a weekend during his period if one of his periods exceeds 30 days. And there's an explanation of how that works at the bottom of page 9 and at the top of page 10. I know this is complicated, and I know that this isn't really how the real world works, because there are summer programs that many people engage their children in during the summer, in part for childcare reasons. But the court order is the law in this case, and the court order says either he gives you in writing the days that he wants them, up to 42 days, or if he doesn't, then he gets to take them at 6 o'clock on June 15th and keep them until 6 o'clock on July 27th. So there shouldn't be any fights about this. This is how it works. And Ms. Jordan, that means that you don't get to say, you can't have them in June because I already scheduled them to do something else. Because you know that the order requires at the very least that he have them from June 15th forward. In addition, that does put some requirements on you, Mr. Brown, to get a written notice of when you want the kids and have the understanding that if you didn't do that, that you get them from June 15th till July 27th.
Yes.
Let me just add one other thing. This schedule, which the legislature imposes on people, can be varied from by agreement. And you all, you know your kids best, and you know if they might resent one or both of you if they don't get to do what they want during the summer. And so I will tell you that
as the hearing continues, the father's requests become more focused, showing he understands that judges respond better to specific remedies than emotional complaints. Instead of simply demanding punishment, he asks for enforcement and practical access to his children.
In my family, I have a couple of wonderful kids who are my niece and nephew, whose father was inflexible and wanted them when he wanted them, and it didn't matter what they really wanted to do. And the result of that was when they were old enough to never see him again, they never saw him again. So being inflexible like that, that can hurt. That can go either way. They can get to the point where when they're old enough to decide they don't want to have anything to do with one or the other of you, if they feel like y'all didn't care about them and about the things they're interested in. But we're talking about what the law requires, and the law of this case is this order. And so it's not good enough for you to say, Miss Jordan, no, we got stuff to do. You can't get them in June at all. You can't. What you can do is you can say, this is really important to the kids. Maybe I'll give you an extra week if you agree not to disrupt their June, and instead let them stay into the first week of August, or whatever it is that you can work out. There's certainly room for you all to reach agreements outside of this order. But this order is the law if you can't reach an agreement. Go ahead.
So yes, I do understand how strong the agreement is. I have read through it. But I'm just asking, in the case of, as we can see in May through April, it's inconsistent. There are times I have to miss work. I am the primary provider for the children. How do I go about without planning ahead for my children? If I didn't plan for the month of June, mind you, in May and April, those days he kept continuously canceling. There was always a reason. When you look in those documents, there's always a reason as to why he can't show up. So in June, I had to make it work. It's summer. I have to figure it out. And if you're going to, I don't know, like, I have to make plans for my children, because there's been too many times where he said he would do something and he didn't. So I do understand the agreement, but at the end of the day, the agreement can't save me or the children from the needs that they need when it comes to the financials and the livelihood and the everyday life of them. So I am not just reading the agreement and disregarding it. I am trying to make sure everything doesn't fall apart, even if he doesn't abide by the agreement. That's all I did in June. And he also said in June, that's great. That gives me time to get my financials together if I can get them for the month of July. So there's never, those aren't my intentions.
Let me say a couple things. This document that you call an agreement is not just an agreement. It's a court order. And the court has said It's the law in this case. So it's not something that you can unilaterally decide to vary from. Now, I understand what you're saying about him backing out of things. But what this order says is that he has to give you written notice by April 1st of when he wants them. And then that does give you time to plan for June and July if he lets you know by April 1st. It also says if he doesn't give you that notice by April 1st, he gets them from June 15th until July 27th. Now, I understand what you're saying, which is if at the last minute or after those deadlines he backs out, then you have nothing to do with your kids. And I get that. And Mr. Brown, you need to understand what's happening there too, because she does need to make sure if you back out at the last minute that she has, somebody take care of her kids.
Yes, I understand. I apologize. I don't mean to cut you off as well. Like I said, I spoke with Ms. Samori since the beginning of January about spring break as well as the summer. Yes, I was not able to come during spring break because spring break and my oldest daughter's birthday run congruently. And I ended up having a last minute expense with my vehicle. What I explained to her, like, yo, I had to pay the registration, so I can't just drive out there this time around. So we kept planning to try to make things later down the line. I asked for another data this week. I think it was within about April. I have the messages for it as well if you need me to find and give them to you, if I haven't sent them. To explaining to her when's another day. This week, she told me she was busy. I said, okay, maybe we can go further down the week and figure it out that when I can come and visit. So, yes, while that was going, I still expressed to her that I really don't agree with allowing my children to not come with me in the month of June. Because of the fact, again, I have never have that ability to fly my children out here. And I do have receipts of me actually buying flight tickets for them before, and she last minute cancels on them on her birthday. I have that if you need that as well. And that was about 5 years ago. This time around, like I said, she did allow me to come within the middle weeks of May. I expressed to her before I left as well. I said, yo, even if this was May 23rd, so I expressed to her, I know they're getting out on the 15th, but I can stay another week if they're just getting out next week, and you don't really need them going back to school because school is pretty much over. We're only doing school activities at this point in time. So if it's okay with you, I could just take the children now, and then bring them back on my allotted time. And if not, that's when they gave her the paperwork and told her, like, you won't let me take them now, I would just come on a day that court allows me to take them on the 15th because of the fact that I did not send her a written notification letting her know by April 1st that I would like more days or not. So I was like, okay, I'm just going 15 because this is. So with that, I let her know. I gave her the video. I contacted her the day prior. I tried to stay in contact with her on the way there. And when I made it there, I didn't get no answer. And even before I even filed this paperwork, I tried to give her a call the day of, the day after and the day of, because, they were asking me, do you really want to do this? And I'm like, I really don't. I just want to get my children, bring them back. If I'm still allowed to come out there when she gives me time, I will do that, and we can keep working it out ourselves. But
once the discussion shifts to transportation and safety, the hearing moves beyond a single visitation dispute into future conflict prevention. The judge is no longer trying to determine who behaved better in June.
But I just can't allow you to keep getting away with things, how things are going. It's just not working. It hasn't been working. So I just... and that's about it.
So what is it you want me to do?
I'm not for, trying to get the mother of my child in trouble, but if she continues, then she will have to suffer whatever consequence she had. But I do feel like right now that the expenses should be on her to send my daughters out here for, I guess, the remaining of the time that I have, if there is time, because I know they have school coming up. So I don't even think that's, I don't know. So I just would like this to be enforced heavily. Like I don't even want to go through. But if this continues, I would like for her to be held in contempt for her actions because it's not conducive for our children.
All right. Your children are 8 and 7, is that right?
They're 8 and 7.
9 and 7.
9 and 7. I'm so sorry. She just turned 9 in March.
So let me just ask you, Ms. Jordan, how old do you think they need to be before they can fly as unaccompanied minors on a flight from Austin to LA?
I don't think there's a age as a minor. It's a lot going on. I just don't think that's appropriate for a 9 and a 7-year-old to fly to California and be at an airport with so many people. Yeah. So
Just to note, in our first court case, the judge proceeding did say that it's at their age that they were at the time, they're old enough to be able to be flown out with an accompanied minor, which I continue to express to her over and over and over. And she expressed to me again over and over that I would have to fly there, fly back, fly there, fly back, which I told her I'm not financially can do. So if you would like to go half with me, I don't mind doing it. But if not, then this is the route that's giving for us to allow me to have my children. And I do agree in a sense, yeah, but if you're not trying to at least meet me in the middle, because I did express to her several times, I will fly you out here and fly you back. You know, if you don't want them to go by themselves, I will fly all three of you. I don't have a problem. And if you would like to take the place, you could take my place. I would sleep in the car, whatever the case may be for you to be comfortable, I would do so. But me having to go 4 trips for that really should be 2, I don't think that's conducive to either of our pockets.
All right. So I want to hear when they start school, Miss Jordan, and what they're doing between now and then.
as far as
Activities.
so when they go to school, they will be in gymnastics. I believe that'll be Monday through.
No, when does school start in the fall?
So school starts August 17th.
And what are they doing between now and August 17th?
So now in August 17th, they're with my mom right now.
And is it correct that Mr. Brown hasn't seen them since he was here when was the last time you were here, Mr. Brown?
I was there May 23rd, but I do want to note that within the past 2 weeks, I've been being gate kept and somewhat alienated from my children. I've been contacting her due to the fact that my children's tablet is not, I don't know if it's not receiving my calls or anything, but we have an app on the tablet called Google Meet, which I've been contacting them consistently and I've been not getting an answer. So I've contacted her several times, asking her, yo, can you have my daughters give me a call? And she would give me answers like, they'll give you a call when they feel like it, or what was the other one? I can't force them to call you if they don't want to call you, things of that nature. And, you know, I think to me, that's like, I don't understand that. Like, you can make my children get up, go to school, wash their butt, do usual things, call whoever they want to call, play outside. You can make them or you want to use the term force them to do everything else, but you can't get them to contact me. And, I, I honestly don't even understand that, like, why is it so hard for her to make my children give me a call if I'm consistently calling you? And if you feel like I'm harassing you, why don't you just, ensure that they do so? Because even when I was with her, stayed at her establishment, she let me stay there for the 2 weeks. I would make sure they call, even if they didn't feel like it or they tired. And, she would contact me every morning, ask me to make sure they call. And I would do so. I would, hey, get up, call your mama, So I don't understand why I not receiving the same treatment, especially because I'm not in the same state. And I'm far out. Now, if there's times that they're not available, we can work it out, but the whole telling me like you can't force my children to give me a call, or it's pretty much not your problem, they're not answering, I think that's asinine. And I don't think that's conducive to even if you're telling my daughters, like, I don't think that's cool to allow my daughters to think it's okay not to answer their father when they're calling, because that's something I would definitely not allow.
All right. So you want to be able to speak with your children regularly, and you haven't been able to do that. Are you also asking that you get your children between now and August 17th when school starts?
Yes.
And how would you propose to get them to LA?
I would propose that she have them fly out here. She can come too as well. If she's not comfortable, she can get on the plane with them. But I feel like it should be at her expense, because at my expense, I drove out there with my car all the way there. And, I wasted $400 and so just a trip there and forward and back. So
This portion highlights a judge who understands that enforcement without practicality creates another round of litigation. The father argues he should not bear every financial consequence after making a failed trip, while the mother wants additional time before the children return to school.
Now, if the expenses is kind of hard right now for her, I don't have a problem putting up half of the funds, to get my daughters out here so they can spend time with me. I don't have a problem with that, because I feel like it's a new recession out here. So I'm willing to work with her however way, but I do feel she needs to input some funds into getting my daughters out here, at least this time around, because
So I need you to explain to me again, when you came here, that you were unable to see them.
Well, what do you mean? On June 15th, I arrived there because I was notified the day prior. I drove her to her house. I knocked on her door. No one answered. I contacted her consistently. She didn't answer my phone calls from Facebook or her phone number. And no one was there. So that's what I meant by that.
All right. So you came here on June 15th to Travis County to pick up your children because the order says that's when you get them if you didn't give notice by April 1st. And
Yes.
you weren't allowed to get them or to see them, and you had to drive back home? Is that what you're telling me?
Well, what I did was I actually stayed out there for the day, me and my son, because I drove with my son. So we ended up, after leaving her house, that's when I went back to the courts and started my paperwork to file for visitation enforcement. And I had to stay another night in my car due to the fact that, the time of everything, I had to go back and do all the filing the next day. So that's when I had left from Texas. Was it the next day? Yes, the next day. Because I live in California, so yeah.
All right. So I see your motion for enforcement of possession and access, and that you filed it on June 16th of 2026. And and then you drove back home to Los Angeles. Is that right?
Yes.
So your response to that is that you had told them in advance that the kids weren't available on June 15th. Is that right, Ms. Jordan?
Not only that, but April, through the entire month of April and the entire month of May, he canceled all of his plans and he finally showed up. And also July, he said he needed time anyways to get his funds together. So that would be great for him to get them the month of July. So that is,
Wait, when did I say that? I'm kind of confused. I need to find that in my ruling book when I explained that.
So I see that you filed a bunch of documents, Mr. Brown. Some of them are screenshots of your communications. And they're not numbered.
Yeah, I should have did better. That's my apology. Is there one in particular that you would need me to look up per se?
I don't know what's happening. Yeah.
Sorry. Well, so what we need to do is, do you want all of these things to be exhibits to this hearing so I can read them and rely on them?
Most of those exhibits pertain to our case now, yes. I may have a couple or two that's just evidence of prior times that shows proof of like a continuance in her I cannot think of that word. I like in which she does like this is like a repetition thing that happens. You know, it get close to the time it's about for me to pick them up. I get this a lot of random stuff happens to where it's not capable. So most of that, yes, that information is yes. Even the video that's shown is actually a video of when I tried to have a conversation with her about speaking to my children. So if that's not need to be used, you don't have to look up the video at the moment. But the rest pertains to.
So are you asking that all of these documents be made exhibits for this hearing?
And by the way, I do want to say that we did have a conversation about the things my daughters will be doing in the summer. And because she was asking me, what would they be doing while I be working? And I told them that if they're not being babysitted, you know, they're going to be with me, you know, because I have a job, I can move around and still have my children. And if not, she didn't really want to agree with that. She did asked if they could be put in a summer program. I did agree with her, like, yeah, I'll put them in a summer program just to make sure you're comfortable with it, as well as like it is a good idea to keep them in a summer program because it can keep them active. She did explain to me several times that she had a child care type of thing that goes with them in the summer, and I told her that like I that doesn't make sense for one. For two, this is a lot of times that's allowed for me in the summer. So whatever you have going within that time, it should not be going because of the fact that this is when I'm able to have them. Yeah, that's it.
So you didn't answer my question, Mr. Brown, which was, do you want me to admit into evidence all of these documents uploaded to Box? And you need to wait for me to finish my question before you start to answer so the court reporter can make an accurate record. So yes, you want these admitted into evidence?
Yes.
Do you have any objections to any of these items, Ms. Jordan?
I don't have any objections to this evidence. No, I haven't really.
All right, so we're going to go in, my court reporter is going to go in and number these consecutively. So there's 1, 2, 3.
The final stage of the hearing focuses less on punishment and more on building a framework both parents can actually follow. The judge narrows every remaining dispute to one question. Can this issue be enforced under the current order, or does it require a formal modification?
Oh, yes, you can take out the, if it's not needed for the court. I do have a couple of screenshots of how much I spent on charging my car. I would say it's 1, 2, 3, 4, 5. It's the first 5, or mine is the first 5.
There are 15 exhibits. I will
Uh-huh.
disregard any that I don't think are relevant, but exhibits 1 through 15 are admitted.
Okay. Understood.
So, next question is there any impediment to my ordering the children to go to Los Angeles to be with their father from tomorrow until a couple days before school starts on August 17th?
Is this as far as like a plane, driving, like my concerns?
So, I'm sensitive to the fact that Mr. Brown came here once to try and get them and didn't get them. The order makes it clear that he pays a reduced amount of child support because of the travel that he's going to have to pay for. And that looks like a trade y'all made back in 2022, and I don't want to disturb that trade. It seems like a fair enough trade to me. So I'm not going to change the fact that he is the one who's supposed to pay to get them from here to Los Angeles and back. If you choose to and can, Mr. Brown, you can drive here and pick them up and take them back. If that's not convenient to you, then you can buy them plane tickets. They need to be non-stop direct tickets from Austin to one of the Los Angeles area airports where you'll pick them up. Ms. Jordan, if you don't want them flying by themselves, even on a plane that doesn't stop, and go straight from here to one of those airports where he will meet them, then you can pay to fly yourself with them. But I'm not going to require him to pay to have you go with them. In the future, to the extent that the order is not clear enough, I'm willing to make a couple of clarifications in the order. And one of them is that at this point, the children can fly as unaccompanied minors so long as provisions are made with the airline to make sure there's somebody who's keeping an eye on them from the time that you drop them off at the airport until the time that Mr. Brown picks them up in Los Angeles, and vice versa. So from now on, that is an acceptable way to do it. The other acceptable way, of course, is for Mr. Brown to drive here and pick them up.
Is there, I don't want to close the case without being able to say the things I need to say.
We're starting to run low on time, but go ahead.
So as far as driving, that's also in the exhibit. He was pulled over with paraphernalia in the car with both of my children. My daughter does have asthma, he was smoking in the car with my daughter with asthma, and my other daughter clearly told him, you can't do that because Serenity has asthma. He did it anyways. When I mentioned it to him, it was that didn't happen. Of course, my daughter is scared. So she is messaging me and she is letting me know what's happening. And of course, her safe space is once she gets to me. So that's when she went in more depth and made them get out of the car and everything to search the car. I just don't agree with the driving. I really genuinely don't agree with the unaccompanied minor either. I feel like that's not in the best interest for the kids, but of course, if that is what's ordered, that's what's going to be done. I've been nothing but nice, as you can see in all of the exhibits in there. I've gave him chance after chance. Every exhibit on there, it shows cancellations. I am trying to abide by the court order and I am trying to do the things I'm supposed to do, but it's crazy to me that, of course, on June 15th, it's ironic that on June 15th, this is when we have the paperwork. This is when you drive out here when you know that they're in place due to your faults and cancellation in the past. So it's like, it's just a lot to sit here and be the accused when I know that even though we swore by the court that none of this is true. So, and it's all in the evidence.
So are you telling me that you have some evidence that you've uploaded to Box?
I've uploaded, I believe, 23 documents of cancellations, of me explaining to him I don't mind the kids going to California, whether he visits. There are multiple things in there.
Okay, I now see that you have an exhibit list and exhibits labeled R001 through R031. Are you wanting to offer all of those into evidence?
Yes, ma'am.
Mr. Brown, do you have any objections to any of them?
I have objection to the what she tried to explain. For one, yes, I was pulled over. For one, I was not smoking in the car with my daughters.
Sir, that's not what I'm asking you.
Oh,
I'm
okay.
asking,
I have no objections. If it's anything would she tried to explain prior, no, I have no objections.
all right. So exhibits R1 through R31 are admitted, as were all of petitioner's exhibits 1 through 15. So those are all admitted. I will look at those.
Concerns about sleeping arrangements, communication problems, and extended family involvement are acknowledged but carefully separated from the immediate enforcement request. It is a disciplined reminder that family court is driven by pleadings.
I agree, Ms. Jordan. If you have a child who has asthma and should not be in a closed space with somebody who's smoking, I agree that the order can be clarified to say that no one should be smoking in a car or in a home in the presence of your daughters. And so, Mr. Brown, if you need to smoke, you're going to need to stop the car at a rest stop and have a cigarette. Yes, sir.
Yes, that is false. Yes, I was pulled over. Yes, I was pulled over. I did one time get back in my car after finishing up on the cigar. My daughter did explain to me like, "Yo, baby has asthma." I expressed to her my apologies, baby. I have since then never did that. So that doesn't even run congruent when I got pulled over by the police. When I got pulled over by the police, I just left her house. And when I got pulled over, they said I was speeding. And yes, they explained to me, yes, your car smells like paraphernalia. I said, well, I just went to the store, if that's the case, to grab some X, Y, and Z. And if you want, they explained to me, they'll take it and throw it out. That was that. I kept on continuing to move. I was not smoking in the car with my daughters when the police pulled me up, because they would have took me to jail. I would have had a whole jail report about that. So that's false.
Also, I would like to add the apartment smelling like weed, alcohol bottles everywhere. When I got back, all over my balcony, all over the apartment. And then also,
Please show proof.
I would like to speak about, sorry, he kind of threw me off. Yes, I would like to the paraphernalia, the alcohol bottles. I would also like to explain the bad mouthing to my children, telling them if your mom does not let me have you guys, which is also in the exhibit as well. You will go to court or have to pay him lots of money. So it's just again ironic that we're here because he's been saying since day one he can have me pay him, he can have me put in jail. So this is just all coming out. This isn't a consistent thing. This is something that's coming out at a time like this. So it's just also ironic to me.
And if that's too late to put in any, for one, that's false. For two, I know we've actually sat in her house together and consumed wine together and all sorts of things. So for her to even try to singulate me like that, like put me like, come on now, so let's not go to the court with that, Miss Jordan, because we've both been in a setting on your balcony when our daughters have walked outside while we were consuming what we were consuming, if we were smoking some or if we were drinking a beverage that was alcoholic. So again,
a glass of wine and alcohol bottles all over my balcony is not.
Alcohol bottles. Please put that. I hope you have my fingerprints on all those bottles.
That was just something that I was telling you.
Like my fingerprints on the bottles. I apologize.
This is not a time for you all to complain about one another, and it's certainly not a time for you to talk to one another. This is a time for you to tell me what it is that you're asking me to do to enforce the possession and access order with respect to your children. And so you're asking me, Mr. Brown, to have the children from now until they go back to school. Ms. Jordan, how long would you want them to be home before school starts?
I need them home at least 2 weeks prior to get ready for school.
That's not going to happen.
Well,
that would have been fine if he'd had his 42 days this summer, but he's not going to get 42 days this summer because you didn't allow him to take the children. So this is a makeup time, and it's not even going to be able to be a full 30 days because school starts on the 17th. So when do you want them to come there, and are you wanting them to fly this time, Mr. Brown?
If they can come tomorrow, that's perfect. Yeah, I would like for them to be flown out here. They're
going to need to buy the tickets. They're going to need to be on flights that are direct and nonstop to whichever airport in the LA area you want. And you're going to have to make arrangements with the airline for them to be accompanied to the airplane and watched on the airplane with the other unaccompanied minors. So I'm thinking you may not want to pay for a flight today for tomorrow because that will be very expensive, but that's up to you.
No, I wouldn't. If there were to fly, I would. Like I said, I was requesting that she provides funds this time for this summer to fly them out here because, again, I did drive out there and make my attempt. So I feel it's only fair that she has to, even if put half on a ticket, do it that way, or even put half on me driving out there to pick them up. Because if I don't have enough funds, I would at least try to acquire the funds to pick them up by driving
So it seems to me that neither of you are blameless in all of this. Y'all need to learn to get along. You're going to have kids who are under 18 for another 11 years. So y'all are going to need to figure out how to get along. If for no other reason than you want your kids to grow up to be well-adjusted adults who are happy, and you want to have a role model for how they treat any partners that they have later in life. And y'all are no longer together, but you need to learn to treat each other with respect. Certainly shouldn't be arguing in front of the kids, and you definitely need to find a way to model the kind of behavior that you want your kids to engage in when they grow up. So as far as how we're going to get them to Los Angeles, I just told you that you're going to have to pay for the flights, Mr. Brown, for both kids. But if she wants to go with them, she'll have to pay for her own flight. So that's my ruling on that. I'm not going to change that. I understand your frustration with that because you already came here. But you have the option of either driving here and picking them up, or making arrangements for them to fly on a nonstop direct flight from Austin to an LA area airport with there's unaccompanied minor provisions that you need to do. And I think it varies by airline. So she's not going to have to pay for that. You're going to have to pay for that. But if she wants to go with them, she's going to have to pay for herself. That is my ruling on that. I'm going to rule, since y'all aren't really tell me what I need to know, that those flights or your being here and picking them up can start as early as Sunday.
The judge leaves both parents with something more valuable than a temporary ruling. She establishes clearer expectations, removes future ambiguity, and makes it far more difficult for either side to justify another avoidable conflict under the same order.
July 26th, or later if you can't get reasonably priced flights because you're too close to the date they're flying. And then their return, I'm going to require that their return be by August 14th, Friday, August 14th. School starts on the 17th. I know that's not much of a buffer, gives you a weekend, but that only gives him really basically less than 3 weeks with his kids when he was supposed to have had 42 days with them this summer. So that's my ruling. Y'all can make arrangements for that. I am going to add a provision that if you drive with them, there's to be no smoking in the car, that neither of you are to use weed or other intoxicating substances while the children are in your possession. I know it's legal in California. It's not legal in Texas. But unless y'all want to agree to allow it to be smoked in their presence, I'm not going to allow it to be used when you're in possession of your children.
Okay, that's no problem. Is that for both parties?
Yes.
Okay. And no consuming beverages?
I'm sorry?
And no consuming of beverages?
So I'm not hearing that either of you has a concern about the other of you drinking to excess in the presence of the children. Is
Yeah.
that's not an issue, but I'm not going to have a rule about alcohol. But I do hear complaints about them smelling weed, and I do know that it's not legal here in Texas, so I'm going to have that rule. I'm also going to make it clear that the kids can fly back and forth unaccompanied as long as it's a direct nonstop. And you make sure that the whatever policies the airlines have for you having them accompanied by somebody from the airline, that you take care of that.
Is there a ruling, or do you have anything like about sleeping arrangements, or that's none of my, I'm not allowed to speak on that?
I don't see a pleading that would suggest that I need to deal with that. If y'all have some other issues with each other, I'm going to suggest that you try to sit down and work it out between the two of you. And if you can't, then somebody will need to file a motion to modify the existing order. But I don't have anything like that right now. I'm trying to deal with your complaints about one another and what we can do to enforce the existing order and whether it needs to be clarified in order to be enforceable.
Yes. So I understand that. And I didn't see anything about sleeping arrangements either, but I do want to make sure, because they're two girls. He does have a 16-year-old son in a one bedroom. So I want to make sure they are also okay. So I guess I can.
That's beyond the scope of what I'm here to deal with today.
Okay.
All right. So those are my rulings. I will draft something and get it filed. But, generally that y'all need to make arrangements to get the girls to LA on those dates and times that I talked about. The other issue that Mr. Brown's enforcement deals with is the ability for the children to speak with the other parent while they're at the other parent's home. And is there anything in the existing order that deals with that?
No, not exactly. We kind of just came to agreement that we will, free to just talk to and call when we want, free to talk to each other. So there was really no agreement on like certain times. Now there were sometimes like when they had school, it was times that I could not call because they were at school or she was at work. But other than that, not in the court agreement, no, not that I recall.
All right. Well, generally, y'all need to be reasonable in allowing your children to access tablets or phones to talk to their other parent when they're with you. If you need something more specific, then you're going to need to file a motion to modify, because I don't see anything in here that deals with that. Is there anything else?
Just aside for the fact that he doesn't consistently call, they always have access to the tablets, and they're not currently with me right now, which is also stated in the evidence. They're just not with me right now. I can't enforce them to do anything. I've told them multiple times, as he's told me, your dad has called. Call your dad. That's what.
Who are they with right now if they're not with you?
They're with my mother right now in Dallas.
All right. And when are they supposed to be back?
So they were supposed to be back. I was supposed to get them next weekend, but I mean.
All right. Sounds like you need to either drive to Dallas or make flight arrangements to and from Dallas, Mr. Brown.
To pick up from her mother's house?
If that's where they are. It may be easier to find flights from Dallas to LA, direct, nonstop. It may be cheaper as well. So let me just say, if you don't have your children and they are with your mom, then you're going to need to make sure that you can comply with the court order by either instructing your mom what to do, or you're going to have to go up there and do it yourself, Ms. Jordan. Okay?
Yes, ma'am.
All right. Well, those are my rulings. I will get you a written order, and y'all are excused.
Thank you.
Thank you. Have a wonderful day.
One of the strongest aspects of this hearing is how the judge controls the pace without becoming confrontational. Every time the discussion drifts into personal attacks, she redirects it toward evidence, procedure, and the specific relief being requested. That discipline prevents the hearing from becoming a contest over who has the longer list of complaints. Instead of rewarding emotional arguments, she rewards organization, legal relevance, and direct answers. Even when both parents attempt to introduce new accusations, the judge separates allegations from enforceable facts before giving them any weight. That courtroom strategy sends an important signal to anyone involved in custody litigation. Judges are rarely persuaded by the loudest story. They are persuaded by evidence that connects directly to the order already in front of the court. The biggest takeaway from this case is that neither parent leaves with complete satisfaction, but the legal framework becomes far stronger than it was before the hearing began. The court transforms vague expectations into specific rules about travel, communication, transportation, and conduct during parenting time, making future disputes much harder to justify. That is often how successful family court decisions work. They reduce uncertainty instead of increasing punishment. The father gains enforceable access and clearer protections, while the mother receives direct guidance on where judicial discretion ends and court orders begin. More importantly, both parents are reminded that every decision they make is shaping how their children will eventually view trust, responsibility, and conflict. In family court, today's legal victory means very little if tomorrow's parenting relationship continues to collapse.